Tuesday, President Marcus Hale walked into a federal courtroom to watch his own Justice Department make a case he demanded. Wednesday, he's calling for that same department's chief counsel to be arrested. In front of reporters, on the record, what happened in between isn't a policy dispute. Sources in the room say it's the closest thing to a total institutional meltdown Washington has seen in decades. I've spent the last 2 days going through court transcripts, leaked staffer texts, and on-record statements. Here's what actually happened. Quick context first. Diane Okafor, 22 years as a litigator, 11 of them inside the Justice Department, appointed White House Counsel by Hale himself 14 months ago. Not a political operative, a courtroom lawyer, the kind who reads statutes for fun. That matters, because it's exactly why what happened Tuesday landed the way it did. The issue, a hearing that was supposed to be routine, turned into the loudest public break between a president and his own legal team in modern memory. Timeline, fast version. Monday, DOJ files an emergency motion Hale personally pushed for, targeting a sitting federal judge's earlier ruling against an executive order. Tuesday morning, the hearing opens. Tuesday, 11:40 a.m., Okafor stands up in open court and tells the judge her office cannot support the motion as written. Tuesday, 11:52 a.m., Hale, who was watching from a side room via video feed, has aides patch him into the courthouse. Tuesday, 12:04 p.m., Hale is in the building. That's the setup. Now the details. First account, from a courtroom sketch artist who was seated 3 rows back and later gave an interview. Okafor told the judge, in essence, that the motion asked the court to ignore its own prior ruling without new legal grounds, and she wouldn't put her name on it. That's not spin. That's what multiple people in the gallery independently described. What it means, this wasn't a quiet disagreement handled in a hallway. It happened on the record, in front of a sitting federal judge. Second account, from a court reporter's contemporaneous notes later shared with 3 outlets. When Hale arrived and was told what Okafor had said, he reportedly turned to an aide and said the word arrest twice before he'd even sat down. Put those 2 things together, a public legal refusal, followed by a president reportedly reaching for the word arrest within minutes, and you start to see why people are calling this a rupture, not a disagreement. Now, what almost nobody's covering, the 7 minutes between when Hale entered the courthouse and when he actually spoke. Aides describe him pacing in a side hallway, refusing to sit, asking 3 separate times whether the judge had already ruled. He hadn't. According to 2 staffers present, that detail didn't seem to register. At 12:11 p.m., Hale walked into the courtroom itself, unannounced, mid-proceeding, and according to the court reporter's log said, "Arrest my lawyer. She works for me, and she just humiliated this country." The judge, per the same log, called a 15-minute recess before Hale had finished the sentence. That's not normal presidential conduct in a courtroom. That's a president publicly demanding the arrest of his own attorney inside a federal building during a live proceeding. Fallout inside the administration moved fast. By Tuesday evening, 2 senior DOJ officials had issued statements backing Okafor. One deputy solicitor general reportedly told colleagues she was not going anywhere. White House communications tried 3 different versions of a statement before landing on one that didn't use the word arrest at all. Here's the piece that's harder to find. A memo, drafted by Okafor's own office the night before the hearing and later described by 2 people who read it, reportedly laid out, in plain language, that the motion as written asked the court for something outside its authority, and that filing it risks sanctions against this office and this administration. She wasn't blindsiding anyone. She'd warned them, in writing, the night before. The White House response came Wednesday morning. Press Secretary Renata Vance told reporters, "The president expects his legal team to fight for him, not against him." Notice the word choice. Fight, not follow the law. Okafor's position, according to people close to her, is that her obligation runs to the Constitution and to the court, not to any one client, even the president. By Wednesday afternoon, Congress was reacting. A senator from the president's own party, someone who typically avoids daylight with Hale, issued a statement calling the courtroom outburst beneath the office. Meanwhile, a group of House allies circulated a letter defending Hale's right to demand loyalty from his legal staff. The party is not unified on this. Not close. Okafor herself has said exactly one thing publicly in a 2-sentence statement released Wednesday evening. "I took an oath to the Constitution, not to any individual. I intend to keep it." 18 words. No apology. No resignation. Hasn't spoken since. Okay, got to be fair here, because the other side has an actual argument, not just noise. People defending Hale point out that White House Counsel serves the president's office and is expected to advocate zealously within legal bounds, the same way any client's lawyer would. Their case, Okafor could have raised her objections privately in advance, and either won the argument internally or resigned quietly rather than blindside the administration in open court. Constitutional attorney Dana Whitfield, no relation to anyone in this story, put it this way in an interview: a lawyer who ambushes her own client in a public forum rather than fighting the fight behind closed doors first arrest has arguably failed her duty of loyalty, whatever the merits of her legal read. That's not nothing. Every White House counsel walks a line between advocate and gatekeeper, and reasonable lawyers disagree about where exactly that line sits. The counter-argument from the other camp, Okafor says she raised it privately first, in writing, the night before, and was ignored. If that's accurate, going public wasn't an ambush. It was a last resort after the private route failed. Where you land on this probably depends on which account of Tuesday night you find more credible, and right now that's genuinely contested. There's also a bigger picture argument Hale's allies are making. Presidents are entitled to counsel who will make aggressive arguments, and an overly cautious legal office can leave a White House unable to execute its agenda at all. That's a real tension in how every administration is staffed, not unique to this one. So, I'm not going to tell you Okafor is simply right and Hale is simply wrong. What the record shows is a public rupture between a president and his top lawyer, an on-the-record call for her arrest with no legal charge behind it, and a legal team that says it warned him first. Whether that's principled resistance or professional overreach depends partly on facts that are still coming out. What legal experts are saying, fast roundup, a former deputy attorney general, now teaching law at a mid-Atlantic university, called the public arrest demand unprecedented and legally empty. There's no crime described here, just anger. A conservative-leaning constitutional scholar, generally sympathetic to expansive executive power, still said publicly that counsel can't be arrested for declining to sign a motion. That's not how any of this works. When commentators who don't usually agree both land in the same place, that tells you something. Where this goes next matters more than what already happened. Legally, nothing requires Okafor to resign, and nothing gives Hale authority to have her arrested. There's no underlying crime being alleged, just fury. Politically, though, this is a pressure test. If Hale's own party lets this slide, it changes what future White House lawyers understand their job to be. Advocate first, gatekeeper never. If instead this becomes the moment where no from your own legal team is allowed to stand, that's a different kind of precedent, one that outlasts this administration. Why should you actually care beyond the drama? Because White House counsel's job at its core is to be the one internal voice that can tell a president you can't do that before it becomes a bigger problem. That safeguard doesn't work if the lesson from this week is that saying no in public gets you publicly threatened with arrest. It's not really about Hale or Okafor specifically. It's about whether that internal check still functions the next time any president of any party wants something a career lawyer says crosses a line. Still unresolved going into the weekend, whether Okafor stays or is pushed out through some other route, since there's no clean legal path to remove her over this. Whether any DOJ officials follow through on threats to resign in protest, and whether congressional allies of Hale's own party keep publicly distancing themselves, which would be the clearest signal yet of how isolated this leaves him. Dates worth watching: a scheduled press briefing later this week, where Vance will almost certainly be asked directly whether the arrest comment was serious, and the rescheduled hearing itself, still on the calendar, where the country gets to see whether DOJ shows up with the same motion or a different lawyer. That's where it stands: a public rupture, an arrest demand with no legal basis behind it, and an administration that hasn't decided yet whether loyalty or the law wins this round.